Every life is worth living. Every life holds promise. Regardless of disability, injury, or expected lifespan, every life has potential, and ending such a life is murder. Today, I want to speak against euthanasia. I've done extensive research about this topic in the past and have studied both sides of the debate involving euthanasia. The case for allowing euthanasia is a growing issue, and it affects everyone. Even if you or a family member is not affected by this option to end one's life, the idea of euthanasia opens a door to an entirely new realm of ethics that affects every human being. At what point do we stop? At what point can we declare that a person cannot make their own decisions? And at what point can we end someone's life for them? In an attempt to clearly present the debate against euthanasia, there are a few things that I will establish. Firstly, I will clarify what euthanasia is. Secondly, I'll provide reasoning as to why euthanasia should not be allowed. And lastly, I'll propose to you the slippery slope or the moral reasons why euthanasia should not be allowed. By the end of this, I hope to show you why euthanasia is a harmful thing to society. And to begin, let's clarify the topic. Euthanasia is a blanket term that covers a few different things. There are essentially two types of euthanasia, active and passive, passive having two subtypes of its own. The first type of euthanasia is active. Active euthanasia involves causing the death of a person through direct action, and one way that active euthanasia is carried out involves a lethal injection of a drug given by a physician. The second type of euthanasia is passive, which has two subtypes. The first subtype is unnatural passive euthanasia. This involves withholding something necessary for life until death. For example, not giving a patient access to water until they die of dehydration. The second subtype is natural passive euthanasia. This involves withholding any treatment that is unnatural. For example, not using a feeding tube for a patient that cannot ingest food on their own until they starve to death. But there is another issue that is not on its own a type of euthanasia. This is when the decision to end a life through one of these means is made by someone other than the patient. One example of this is the case of Terri Schiavo. Terri Schiavo's heart stopped beating long enough that a lack of oxygen to her brain caused irreparable damage to certain areas of her brain. One result of this was the need for a feeding tube. Her husband believed that she should not have the feeding tube and should be allowed to die, while her parents wanted to take on all medical costs and keep her alive. The husband fought for 7 years in the court system to have the tube removed and eventually won, and Terri died 13 days after the tube was removed. Another example is the case involving Dr. Harry J. Housden. In November of 1915, a child was born in his hospital with several deformities. He made it clear to the parents that without surgery the child would die, and he advised the parents against the surgery. Because of this, the child died, and the doctor became an inspiration for people to speak out about letting deformed infants die for the benefit of society. Euthanasia covers both active and passive, as well as any variations of the ending of a life through medical means, or the lack of medical means. There are several different practices covered under the term euthanasia, but all of them end the same way, with the unjustified death of a human being. Euthanasia should be illegal for several reasons. Not only is euthanasia not considered a constitutional right, but euthanasia is nothing less than murder. Proponents of euthanasia claim that the right to die with dignity is included in the right to privacy. However, the Constitution provides no direct allowance for any form of euthanasia, and while the Supreme Court typically rules right to privacy on a case-by-case basis, the Supreme Court has never ruled that any form of euthanasia is permissible under the right to privacy. And for clarification, euthanasia is murder, because murder is defined as the unjustified taking of a life. and the exceptions or justifications for taking of a life are very clearly outlined in the statutes of the law. Nowhere is there a clause for euthanasia as a defense for murder, and nowhere is there a clause for anything related to euthanasia. Euthanasia is legally unacceptable according to the Supreme Court and by extension according to the Constitution. But there are not only legal reasons as to why you should oppose euthanasia, there are also moral reasons. Euthanasia is morally unacceptable, and if we allow it to occur in any capacity, far worse consequences can arise than the loss of one life. Once it begins, we fall prey to the slippery slope. More and more will be allowed because once we cross this line, there is nowhere else to draw the line. If euthanasia is allowed or becomes acceptable, society as a whole will suffer. There is a conflict of interest for a physician. There is the targeting of the disabled and low-income patients. And of course, there is the question of where does it stop? The first problem is a conflict of interest for a physician. A physician by nature is a healer. So at what point does the healer decide that healing is no longer the correct option? At that point, the position of a physician is no longer what it is intended to be. At that point, where does the physician's priority lie? Should their position be to heal the patient or to end the patient's life and thereby end their suffering? This also opens up a financial conflict of interest for the physician. Should time and resources be wasted on a patient who is considered a burden to society because of a disability, or should a physician save months or maybe even years by ending it now for the patient and offering the option of euthanasia? The second problem is that euthanasia targets the disabled and low-income patients. And now, it might seem like common sense that euthanasia targets the disabled because of its very nature, but it becomes a problem when patients dehumanize themselves. They see euthanasia as a way to relieve their loved ones of a burden. Allowing euthanasia puts people into a mindset that is unhealthy, that in fact encourages suicide. Euthanasia also targets low-income patients. According to the International Task Force on Euthanasia and Assisted Suicide, the cost of the drugs required for active euthanasia cost around $35 to $45. Similar to the previous issue, a patient might feel like a financial burden to their family and choose to end their life. And so again, euthanasia encourages people to commit suicide. The third problem is the question of where it ends, or the slippery slope. At what point can that decision be made for them? In the case of children, parents would be legally responsible for making that decision. Is it morally acceptable for a parent to give a physician the order to lethally inject their child? It would essentially give any parent the ability to kill their child under the guise of ending pain for them. Moving past children, who else can have that decision made for them? In the case of Terri Schiavo, her husband made that decision for her because she had brain damage. But she was not brain dead, she was not in a vegetative state, and she was not unresponsive. So at what point do we declare that someone else can have you euthanized? How can you set a standard for how disabled or how damaged one must be to take away their right to live? Because that is essentially what will happen. There must be a requirement that someone be of sound mind to undergo euthanasia. There must therefore be a standard for how sound of mind you must be. So where do we draw that line? Well, inevitably, that decision would fall to the government. They would regulate who can choose for themselves and who can be chosen for. In fact, this very statement was made on behalf of the Supreme Court. No judge, no matter how learned, can assess the quality of human life and determine as a matter of law that putting an end to suffering is justifiable in one case, while in another case it is not. This sort of subjective determination would be unavoidable if we begin through judicial intervention to decide who shall live and who shall die. If euthanasia is allowed, vast consequences come along with it that extend past the single death. Because of these moral consequences, as well as the illegal nature of euthanasia, it should not be allowed in any capacity. The many different types of euthanasia, including active, natural passive, and unnatural passive, all result in death. No matter how you frame it, it is considered murder by the Supreme Court and by extension the Constitution. Not only is it illegal in nature, but it is also immoral. It causes the dehumanization of patients and pushes people towards an untimely death because of this. Every life, no matter how short or limited by disability or constrained by capacity to function, has potential. Every life is precious and should be protected by the law, not condemned to death by it simply for existing.